she said that she was going to kill me. She didn't know how.
All right, friends, let's go back to Wade Mercer's court in Florida. It looks like they're coming back in. Let's see if they're going to move forward.
In the courtroom, and Mr. Axon's had a chance to speak with Ms. Barfoot in private. And Mr. Axon, tell me what you want to do, sir.
Your Honor, I've had extensive contact with my client regarding the issue of the continuance and the possibilities of the outcome of today's hearing, and she's ready to go forward.
Okay. So you're waiving any, other than the objection that you've already made, which you've asked for a statement of particulars, and I'm willing to grant that potentially, but I can't do it today.
Yeah.
And I've also offered a continuance in fairness, but in light of everyone being here and the similarities between the current charge and the prior charge, you want to go ahead and go forward.
I do want to go ahead and go forward, although I'm not, even if I understand the statement of particulars, I think that I can make the proper objections in order to remedy that situation. So
Okay.
I think we should be fine.
Fair enough. All right. So given that, we'll go ahead and go forward. Mr. Mitchell, I will ask your office, don't do this anymore. There's the day before a hearing, when you know that Mr. Axon was in trial, because you told me that he was going to be in trial. So there's just no, y'all should be looking at your cases earlier, especially one set for bench trial. When this was set for bench trial 2 weeks ago, the state should have looked at the file and said, okay, do we have her charged like we want her charged? And if not, then fix it. But given Mr. Axon's position, we'll go forward. And you want a short opening statement, Mr. Mitchell, or would you like to move straight to testimony?
Just a short one.
Okay, go ahead, please.
Just basically telling the court what to expect today. State is intended on offering a copy of the injunction that was issued on 5/7/25 for the benefit of Elizabeth Norton. You'll hear testimony from Ms. Norton about, what led her to petition for these injunctions. She's going to tell you how even after the injunction was issued, the harassment, as she will call it, didn't stop. It got to a point where, at the advice of Sergeant Quentin Hollis of the Sneads Police Department, she started documenting moments of her days in which she felt like she was being harassed, or there were moments in which she thought that the injunction was being violated. We're mainly going to focus on a period of 1 month in which, according to the testimony from Ms. Norton, Marlene Barfoot contacted her directly or indirectly. 2 statements in which Ms. Norton will testify to hearing, and 1 in which she actually documented. One of these statements that I just mentioned was captured on a cell phone video, which was recorded by Ms. Norton herself. And finally, we'll introduce testimony and videos of a spotlight that was placed on the property of Ms. Barfoot's that's facing in the direction of Ms. Norton's residence, which we anticipate will further go to show that this was intentional contact on behalf of Ms. Barfoot, and leading to the state proving its case beyond a reasonable doubt that Ms. Barfoot did willfully contact, otherwise indirectly or directly, Ms. Norton after having been issued an injunction. Thank you, Your Honor.
Thank you, Mr. Axon. Short opening statement.
Your Honor, I'll just defer until after that.
Fair enough. First witness, Mr. Mitchell.
Your Honor, state will call Elizabeth Norton to the stand.
Ms. Norton, good morning. I'm going to ask Ms. Williams, our deputy clerk, to place you under oath, and then we'll get you to have a seat, ma'am. Ms. Norton, come on around and have a seat. Take your time. When you get in that chair, just make yourself comfortable. And Mr. Mitchell, the prosecutor, will ask you questions first. Mr. Mitchell?
I'll make sure she gets that mic adjusted properly. Good morning. Can you introduce yourself to the court?
My name is Elizabeth Joan Norton.
And Ms. Norton, are you currently employed anywhere?
No, I'm retired, disabled.
All right. What is your current residence?
8183 Pope Street in Sneeds.
It's Sneeds, Florida,
Correct.
which is in Jackson County, Florida.
Yes.
And how long have you lived at that address?
I think about 13 years,
Do you,
somewhere in that area.
I apologize, I interrupted you. You said 13 years.
I think so. I
Do you rent or own that address?
own it.
Now, Ms. Norton, do you know an individual by the name of Marlene Barfoot?
Yes.
How do you know Ms. Barfoot?
She's my neighbor.
How long have you known her?
Probably about since maybe 2019, I think.
How long has how long have you two been neighbors?
Maybe 7 years.
So,
I knew her because she moved next door to me.
so you said she lives next door to you.
Yes.
Do you know if anyone else lives with her next door?
Her husband and her mother.
So can you describe your relationship with Miss Barfoot? Have you always been on good terms with her?
Decent. There've been a few questionable things happen, but for the most part, we, just regular neighbors.
Have there been any issues between you two?
In March, we had an issue, a big thing happened.
What was the issue in March? And I assume you're talking of March 2025.
Right.
What was the issue that happened in March of 2025?
I think it was around the 22nd of March. She came out I was outside cutting a little strip of grass, and she came outside and said that, motioned for me, to come over to the fence, and I have a chain link fence that separates our property. And so I stepped over to hear what she had to say, and she called me. Well, first she said, "Fuck you." And she tilted her head like she was trying to be cute and or coy, and then she's, called me a bitch and just went off. It just continued to curse me. And she caught me off guard with that. I didn't know why. We hadn't had a previous argument. So it just sort of stunned me, I couldn't, there wasn't any reason for it. But she gave me a pretty thorough cussing, and we kind of went back and forth a little bit. And then she headed on inside, and I went on and continued to cut the grass. And
hold on, Ms. Norton. I know the answer is getting a little bit long. I just want to shorten it. Did you contact law enforcement as a result of this?
yes, I did.
Did you speak to law enforcement?
Yes, I did.
Do you remember who you spoke to?
Officer Hollis was dispatched.
And you informed him what happened?
Bad that because when she was talking, she was bouncing up and down like people do when they were wanting to fight or something. And I talked to him about it. and he said he would go over and talk to her.
Did any other, you don't have to go into details, but did anything else like this?
From my house, and after he talked with her, she started ranting and raving. She was like in her front yard, and she was just screaming out that I was a whore, and went through all the cussing again. And then she said that she was going to fucking kill me. She didn't know how or when.
Did this behavior continue in the following days?
Well, I called for Mr. Hollis to come back. He talked to her again, and yes, the it continued. It just like a pattern just sort of developed.
Did you file for an injunction based on this?
Yes, in April, kind of just, well, it scared me because the injunction was granted that same day. And then on May the 7th, we went to court and it was granted by Judge Garcia for 6 months.
For 6 months? Okay. Or I may have a personal witness.
Yes, sir.
So, Ms. Norton, I'm showing you what has been marked as State's Exhibit A. Can you tell me what this is?
It's the final judgment for protection against stalking.
And this is the injunction that you received on May 7th, 2025.
Right.
And just a moment. And is that your signature on the final page?
Yes, sir.
Or, yeah, final page?
Yes.
Okay. Your Honor, State will move to enter State's Exhibit A into evidence.
Donna, your sticker's numerical or alphabetical or neither? Okay,
We do have a mark right there.
that doesn't help at all. Yeah, we gotta use their sticker. It's just, I didn't know if hers were numerical. The state always uses letters. For some reason, we use numbers. So I don't know if it makes a difference really. Mr. Axon, any objection to State's proposed Exhibit A?
No objection, Your Honor.
State's A have been admitted into evidence then.
Now, you said that you two are neighbors.
You have to put it on the back of the front page. Put it somewhere, and I'm gonna see that once you get it marked. I'm sorry, go ahead, Mr. Mitchell.
Oh, it's no problem, Your Honor. Now, you said that you two are neighbors. How does compliance with the injunction work with you two being neighbors?
Well, it could have worked, but it didn't because she couldn't stop saying things.
Well, actually, let me ask you a different way. Did Judge Garcia, you said it was Judge Garcia that signed the
Right.
injunction. Did she enforce special conditions given the circumstances?
She said that, she could live in the house, in her house with her husband, and that for her to have no contact.
Did Judge Garcia also say there will be no forms of harassment?
Objection, Your Honor, calls for hearsay.
you're asking her, did Judge Garcia say that? Are you, and you're saying that's hearsay? Are you asking what's in the order?
Yeah, I'm asking what's in the injunction.
Okay. And tell me how that's hearsay.
I think that the way he phrased the question was, did Judge Garcia say?
Yes, I think that's a
Yeah.
valid point. So if you want to be clear, clarify that question, please. I'm going to sustain it as to the form of the question.
Was there a condition of no harassment?
Yes,
And after the injunction was granted, did the harassment stop?
no,
Do you recall how many more incidents there were?
through the end of July, there was probably a total of maybe 13 incidents.
And when did you contact Sergeant Hollis after the injunction was granted?
Um,
And well, actually, let me change that question again. Did you contact law enforcement shortly after the injunction was granted?
yes,
Was it Sergeant Hollis?
I think Sneeze only has two policemen, so yes, it was, I called dispatch and they sent Officer Hollis.
Okay. And did you document these incidents?
Yes,
Why did you document them?
well, Mr. Hollis had told me that I should do
Objection, Your Honor,
that.
hearsay.
Sustain.
Were you advised to document these incidents?
Yes,
And where did you document these incidents?
I kept them in a little notebook.
And who did you provide a copy of this notebook, or would you also call it a journal too?
Journal. I call it a journal. I provided a copy of it to state attorney. I provided a copy of it to the Sneeze Police Department, which I think they forwarded it to you in your office. I gave a copy of it to Jan Miron, or the attorney that I used in the injunction. And I think that's it.
Okay. Your Honor, may I approach witness again?
Yes, sir.
I'm also now showing you what's been marked as State's Exhibit B. What am I showing you right now?
Beginning page of the journal. Yes,
Okay, and this is your handwriting.
yes,
So you recognize this as a copy of what you provided from your journal,
yes,
and it's in a fair and accurate depiction as it is in your original journal.
it's the same.
Okay. Your Honor, State can move to introduce State's Exhibit B into evidence.
Your Honor, I believe it goes beyond the scope of the information at some parts. It appears from the report and the information, there's 4 incidences that we're talking about. I know that she said there's 13. Unfortunately, the state only filed on from June 28th until July 27th. There's been 4 instances on that. So are we trying to admit the entire journal or just on those 4 instances?
Mr. Mitchell.
I can cut it down to just those incidents from June 28th to July 26th.
Then there's no objection.
And I can give that portion, or we could just get the whole copy and change it later on right now. Okay. We'll introduce it right now and reserve to fix it later on for purposes of time savings.
So I need you to take a yellow sticky note, something to show me where to start reading and where to not read then.
Okay.
So I don't want to look at something that's not in evidence. But it'll be admitted in evidence with the agreement that this document's going to be substituted and replaced by another document that cuts out any dates that aren't charged, which is anything before June 28th or anything after July 27th.
Your Honor, I believe that's going to be page 13, and this is her numbering. I don't know if it's specifically page 13. through pages 22. That's right. Or 23, 22, 22.
Are you going to ask her questions about that exhibit now?
If she needs it as a refresher.
It looks like it's a pretty simple process to go ahead and get someone in your office started working on getting that done.
And I have a copy of it if she needs it for a refresher.
Okay, so let's go ahead and get someone in your office working on getting that modified. That way we don't have to worry about me looking at the wrong thing. If you've got another copy. So that's submitted in evidence with that stipulation. All right, Mr. Mitchell.
Now, let me ask you, when you started documenting these incidents, did you carry your cell phone with you?
Most of the time I did. I tried to. Before this happened, I really wasn't used to carrying it, but I've tried to carry it with me most of the time
And why were you doing that?
because I never knew when something was going to happen, and things had happened when I didn't have it with me, and I really couldn't prove what had taken place without it.
Was it your intention to always record when you were out in your yard?
No, I didn't always record. I just had it in case I saw her outside or something, and if I was working in an area close to the fence or whatever, something might happen, so I was prepared.
Okay. So let's talk about an incident that happened on June 28th, 2025 at about 7:40 PM. Do you remember that date and time?
June the 28th.
Would it be helpful if you reviewed your journal for purposes of refreshing?
That was the day when she was going out. I'm pretty sure it was the day she was going out to her garbage can, and she said, "You goddamn bitch, you're not the one that fought in the damn war. I am."
And was she looking at you when this happened?
Yes,
And you said you've known Miss Barfoot for a long time, close to 7 years.
yeah, I think so.
So you recognize her voice.
Oh, yeah, I could see her.
And what was it she said to you again?
"You goddamn bitch, you're not the one that fought in the damn war. I am."
Was she looking in your direction?
Yeah, she was looking the whole time she said it. She was looking at me, and I didn't see anybody else out there. And, you know,
Could you see if she had a phone in her hand?
no, she was putting something in the trash can. So I didn't see any phone.
What about on July 4th? Can you recall something that happened on that day?
Yes.
And what happened?
I was going out to the roadside to get my trash can to bring back to the yard. And Marlene started yelling out, "Thank you so much. I hope you know the Lord and know his ways." Something to the effect of, "Don't expect the drunks to protect you. and snakes and rats, and then she laughed. Um, you know,
Okay.
I don't know where that came from.
And once again, was there anyone else in your yard?
Nobody in my yard but me.
What about in her yard?
She was the only one outside in her yard, standing in her yard. There was a car pulling out of her yard. And, I saw her over there and I looked and she was giving me that look like somebody would, like, to make sure somebody's looking at them. And, that's when she started shouting. To begin with, she was facing the vehicle that was just about out of her driveway. And once it was gone, she, turned completely toward me and was yelling.
So she was looking at you when she said this.
Oh, yeah.
And did you capture this on your cell phone?
Well, I captured the volume and I thought I had it turned toward her, but I had it turned toward my feet, the cell phone. So all I got was the volume on it.
So, and by volume, you mean you captured the audio?
Yes.
Okay. Your Honor, approach again.
Sure.
Ms. Norton, I'm showing you what's been marked as State's Exhibit C. Do you recognize this exhibit?
Yes.
And how do you recognize it?
I watched it and initialed it.
Okay, so you have reviewed the contents of this disc,
Yes.
and it fairly and accurately depicts the video that you recorded on July 4th.
Right.
All right. Your Honor, at this time, State will move to introduce State's Exhibit C.
No objection, Your Honor.
State's Exhibit C be admitted into evidence. Do we have B back?
Do we have? Okay.
We need to get B and marked and introduced. Or at least it's already been introduced. We need to get it to the clerk.
C, and Your Honor, State will request permission to publish C.
Granted.
I'll play it from my computer again, but it is the exact same copy on there.
Okay.
I'll wait for Dawn to finish up. Okay, I just need TC1. Ms. Norton, there is a screen. It'll go to that right in front of you if you want to look at that one. Now, Ms. Norton, I know it was very faint on the audio, but could you hear Marlene Barfoot in that recording?
Yes,
And could you hear the words snakes and rats?
yes,
Objection, Your Honor. Sustain. What she could hear on the audio is irrelevant.
Okay. But you recognize that as Marlene Barfoot's voice.
yes.
All right. Let's go to July 26, 2025. Can you tell me what happened on that day?
That was the day that that she had a motion of the surveillance camera that whenever I walked anywhere in my yard, my backyard and the front area, like I'd been somewhere, so I came through my front gate and I heard something talking and I couldn't figure out what it was. And so I just I kept walking in the yard and then I heard, smile, you're being recorded. And everywhere I walked in my backyard, I heard, that was said, smile, you're being recorded. And that's the first time that the camera had talked to me. And everywhere I went over the backyard, it kept saying, smile, you're being recorded.
Was that on July 26th?
I thought it was, or
If you were to look at your journal again, would that help refresh your memory?
probably would.
Okay. Okay.
Yep, go ahead.
Norton, just read that silently to yourself
Okay.
and let me know when you're done, okay?
Um,
Don't read it out loud, just silently.
I'm done.
Oh, you're done, okay. So was it July 26th that the smile you're being recorded thing happened, or was it something else?
I think that was July, maybe the 24th, I think.
What happened on the 26th?
Um, I noticed that there was a bright light shining over into my yard from their backyard, and it was like a brilliant bright light that shined all night long up into the next morning. Like it was on, but as it got dark and I looked out the window, it was just like blinding. But there was no point in it being on because the way it was positioned, it was just shining straight at the back of my house. It wasn't benefiting anybody in their yard. It was just shining straight at my house. And I called the police department because
Hold on. Let me ask you this question right quick. So you were able to observe the spotlight, correct?
yes,
And was that the first time you had seen that spotlight there?
yeah, that's the first time that had been done.
Okay. And did you record a video of the spotlight,
Yeah, I took several pictures of it.
but also recorded it?
Yes,
Your Honor, may I approach the witness one more time? Sparkfoot, I'm showing you what has been marked as State's Exhibit D1 and D2. You recognize this?
yes.
How do you recognize it again?
I initialed it that I had seen it.
And you did review the contents of this disc of both D1 and D2.
Yes,
And it fairly and accurately depicts or represents what you recorded yourself on July 26th.
yes.
Okay. This time, statement, to introduce State's Exhibit D in the evidence.
Objection.
Your Honor, can I look at those before we get to them? I think I know what they are. I want to make sure. I thought it would just be one exhibit, so.
It's basically. Are we all?
Your Honor, I have no objection.
Okay, that'll be admitted in evidence as State's Exhibit D.
It's,
Two different videos.
yeah, it's two different videos of the same thing.
Is it on one DVD?
It is on one DVD.
So we're going to call it State's Composite Exhibit D because it's on one physical piece of evidence.
And the state will request permission to publish.
Granted.
Like before, I'm gonna play it from my computer, but it's the exact same videos. I believe me and Mr. Atkinson have stipulated that on Exhibit D1, we're gonna start at the 55-second mark and just go to the 105 mark.
Is that what's been introduced in evidence?
Yes, that's what's being
Your Honor,
introduced.
there's been a little bit more on that video. I think the only relevant portions are what you're looking at from that part to that part. The other parts are just walking. That's what I've seen. So.
But what I have to make sure is what you're showing me is what's in evidence.
Yes.
If this is ever appealed and what that DVD is watched, there's nothing on that DVD outside of what you're showing me.
Your Honor, let's just play the whole thing. That's
Yeah,
fine.
we'll play the whole
That's
thing.
fine.
Yeah, we'll play the whole
It's
thing.
got a match.
It's only 3 minutes and 55 seconds,
Okay.
so play the whole thing just to be safe for appeal purposes.
Okay.
And Don, I need prosecutor PC one. Also, very quick, Ms. Norton, where are you currently standing in that video?
I'm coming out my front door.
Now, Ms. Norton, did you contact law enforcement about this incident?
Yes, sir.
And who did you speak with?
Mr. Hollis.
Okay. And did he come out to your property that day?
Yes, he did.
And after he left, did that spotlight stay on?
Yes,
How long was it on?
all night up until sometime on into the next morning.
Okay. And that is where we will publish State's Exhibit D2. Oh, wait, yeah. Reconnect.
So when is this next section from, the next morning?
I think so, yes. That is next morning, correct?
I think so. Yeah.
Ms. Norton, you just observed it based on the angle in which that light was positioned. Is it facing towards your house?
Yes.
And do you have a spotlight like that?
No.
Okay.
But I don't have one that I have ever used. I have one, but I don't think I've ever used it.
Okay. Ms. Norton, can you describe to the court how you feel every time you leave from outside of your house, from inside your house?
Your Honor, if I may, I'm not sure that that is relevant to the elements of the crime. However, I do believe that's relevant to the temporary injunction itself. If he is going to open his door, then I will be able to cross-examine her on that. That's just, so I don't really, I'm raising an objection to relevance at this point in time, but understanding it's within the discretion of the court, I would ask to be allowed to cross-examine on that if that comes in.
It is relevant, and let me tell you why. She's accused of violating an injunction for protection. And one of the ways you can violate it, according to the jury instructions, which I have pulled up, is willfully violating the injunction by committing an act of stalking. I know I saw that in here.
And Your Honor, we're
And so,
following.
if that's the state's legal theory, stalking does have to do with harassment, which does have to do with the perception of the alleged victim. So is your theory that she violated the injunction? Let's look at your information.
Your Honor, I believe the information says.
Stalking or
484.
cyber stalking. I'm sorry, go ahead, Mr.
I believe it's under section 784.0487, subsection 4A4.
Let's look at that then. So the allegation is she violated it by telephone and contacting or otherwise communicating with the petitioner directly or indirectly unless the injunction specifically allows. So she's not accused of stalking. She's accused of violating the injunction in a very specific way. Telephoning, contacting, or otherwise communicating with the petitioner directly or indirectly. So tell me how her mental state or her perception of it is relevant, given that's the basis for the violation, Mr. Mitchell.
I'll just strike that question.
All
Let's move on
right,
to
sustain the
next one.
objection, then go ahead, Mr. Mitchell.
Finally, Ms. Norton, is Marlene Barfoot in this courtroom today?
Yes,
Can you please point her out and identify her by an article of clothing?
this is Marlene with a pinstripe jacket on and white hair.
And you pointed to your left?
Yes,
All right, Your Honor, let the record reflect that the defendant has been identified,
The record will so reflect.
and the state will tender the witness for this time.
Okay, and Mr. Axon, any questions?
Yes, Your Honor. Now, I want to start with the July 26th incident first, if you don't mind. You had stated that there was a spotlight shining in your backyard, correct? Is that right?
it shined in my backyard, in my windows.
Okay, so you go out your front door in order to get to your backyard?
I live on a corner, so the way it's situated, my front yard, and like I go out this way to my front yard, and then I guess this would be my side yard, but I call it my backyard, just the way the place is set up.
Okay, and you're on Pope Street, correct?
I live on the corner of Pope and Legion Road.
Okay, and so you're saying that your backyard is on Legion Road and your front door is on Legion Road. And so your back door would be on Pope Road or Pope Street?
Now, this was the way it was when I moved there, and it's the way it's always been, because
Ma'am, I'm
my
asking
aunt
you,
lived
is your
there.
front, is your back door
My
on
house
Pope Street?
faces Legion Road,
Okay.
and the entrance to my home is Legion Road. There's no gate on Pope Street. My address is Pope Street, but I have a solid chain link fence down Pope Street, and so there's no entryway to come in that
I understand.
there.
Okay,
And-
so let me ask you a question, okay? So just to be clear, you exit your front door to get to your backyard.
Yeah,
Okay. So did you, and I think I may have asked you this before, who hung up the spotlight there?
who put the spotlight there?
Yeah.
Well, it's one of two people next door.
So you don't know?
I don't know.
So moving on to July the 24th, I think is what you said. Is that correct? What happened on July 24th?
That was the motion detector.
Okay, or is that July 8th, or do you know?
Well, I know it was toward the end of July with the motion detector and the spotlight being very close together.
Okay. And how long has that camera been there? Do you know?
I don't know about that camera, how long it has been there.
Okay, but there was other cameras that were there prior to July 8th or 24th?
It's my belief there had been another camera there prior to this one.
Okay, prior to the entry of the injunction, correct?
Yes,
Okay. But your chief complaint here is not the camera, it's just that the audio recording of Smile, you're being recorded of the camera, is that right?
well, it bothers me being recorded all the time.
Okay, but it was there before the injunction, it didn't bother you. Is that right?
It's always bothered me.
Okay. So who hung the camera there?
The Barfoots.
Okay, which Barfoot? Was it her mom? Was it Mr. Barfoot? Do you know?
Well, it was Mr. Barfoot or Mrs. Barfoot.
Okay, so you don't know.
I would imagine it was one of them.
Okay, so you don't know who hung that camera up, do you?
No,
Okay. Now, moving on to July the 4th, and I'm going to look at your actual journal here. Do you recall what you had put in your journal, ma'am?
well, I'm not looking at it right now, but I've pretty much had the gist of it.
Isn't it correct that you actually believe that she was yelling at the occupants of the car?
I believe she was putting on a show.
Okay, so you're speculating that she was actually trying to make contact with you, even though from your observations, she was making contact with the occupants of the car.
She was putting on a show to get my attention is what she was doing, because she looked over to make sure I was watching before she put on her show.
So,
And the car drove off, and so it kept on going.
okay, so you assume that because Mrs. Barfoot had looked in your direction and then turned around and started talking to the occupants of the car, that she must be talking to you.
They were driving out the driveway. They couldn't,
And
I
you're
couldn't
saying
hear
she-
her
And
talking.
you're saying she was yelling.
Yeah, she was
Okay,
yelling.
and they were backing out of the driveway, correct?
I saw what they were doing, and they weren't looking at her.
Okay, and she wasn't looking at you either. You said she turned back around towards the occupants of the vehicle, correct?
Just all that happened in just a brief couple of seconds.
Okay, and specifically, this is the snakes and rats incident, correct? The one that we
Yes.
saw on the video, right?
Yes,
Okay, and that happened on July 4th, 2025, 6:35 PM?
I believe so.
Okay, and then you also put in here, July 4th, 2015, 6:35 PM. Are you getting your dates mixed up or what happened there?
That's just called an error.
Okay, a scrivener's error, right? Is that right?
I'm really not sure what Scrivener is.
A writing error. You didn't,
Yes, I just made a error.
So
Okay.
where's the error at? Help me understand that again.
Page 15, middle of it.
Okay, go ahead, Mr. Jackson.
now, so the incident on July 4th, where you've labeled July 4th, 2015, is actually the same incident that you're talking about on July 4th, 2025, correct?
Yes,
Okay, so on page 14 of July 4th, 2025, there was a car there, right? And that's at 6:35 PM, correct?
yes,
Okay, and then at 6:35 PM on July 4th, which is on page 15, now you're saying that Marlene yelled at you.
she was getting her point across. She was yelling at me. It was all done for me to hear.
Okay, all right. It was done for you to hear, not to make contact with you indirectly, directly.
That's exactly what it was.
Okay, even though she was directing her contact towards someone else.
There was no one else listening to her.
Okay.
It was for my benefit.
Okay, so she could have been yelling at the occupants of the car like you put in your journal, but you assumed that was towards you.
Your Honor, I'm going to object. I think she's already answered this question.
Your Honor, I think she's being a little bit evasive with her answering, but I can understand the court's.
Yeah, I think she has answered the question. So go ahead
Okay.
with the next question, please.
Now, Marlene normally wears a phone earbud in their ear. Is that right?
I have no idea.
Okay, didn't you put that in your journal also?
Think I have said before, I didn't know if she had an earbud.
Okay, all right then. And you said that she was talking about the July 26, 2025 incident. Did you, you said she didn't have anything in her hands, no phone or anything like that, correct?
Your Honor, he may have the dates wrong or something.
I'm sorry, June, is it June 28th? That's right, June 28th, 2025. You said she was taking out her trash?
Yes,
Okay. You understood the question, right? She was taking out her trash.
on June the 28th. or
Yes.
Ju-
Would you like to refresh your memory?
Yeah.
Okay. May I approach?
Yes, sir.
no.
Did that adequately refresh your memory, ma'am?
Yes,
Okay, so was she taking out her trash that day?
yes,
Okay, and I believe that this was the day that you said, she stated you, and I'm not going to use the words, but GDB, I'm the one who fought in the D war. Is that correct? Okay.
right.
All right then. And I think you just stated she typically will wear an earbud in her ear,
I
right?
never have said she typically wears an earbud.
Okay, but you've seen her, you know she wears an earbud,
No,
right?
I don't.
Okay, but you put that in your journal, didn't you?
I just said I didn't know if she had an earbud or not.
Okay, so you didn't know if she had an earbud or not, right? So it's possible that on June 28th, 2025, she had an earbud in her ear while she's taking out the trash. Is that a fair statement?
Your Honor, objection, speculation.
Where in the journal does it mention the earbud? I'm missing that.
Your Honor, it's not in the June to the,
Somewhere in the part that wasn't admitted in evidence.
That's correct.
Okay, so I'm looking for something doesn't exist, at least in what I've got. Okay, so what is the question and what's the objection again? I was trying to find the earbud thing. I'm sorry.
Trying to speculate that she had an earbud in her ear at the time.
And your point is that
Your Honor,
somewhere else in her journal, she said something about an earbud. And your question is, you don't know whether she had an earbud or not.
that's correct.
That's a fair question. So you can answer the question if you can.
I have no idea.
Do you know the family dynamic of Mrs. Barfoot and the rest of her family?
I'm not quite sure. I know where you're getting at.
Okay, you know she's married.
Mm-hmm.
Is that yes?
Yes,
You know she has a daughter.
yes,
You know she has a mother.
yes.
Do you know she has a sister?
No, I don't think so.
Okay, do you know what the family dynamic is between her daughter and herself, or her sister and herself?
Objection, relevance.
Yeah, I'm curious about the relevance too.
Your Honor,
How's this relevant?
I'll move on.
Okay.
That's all the questions I have, Your Honor.
All right, any other redirect, Mr. Mitchell?
Briefly. Ms. Norton, when that statement was said on June 28th, was she looking in your direction,
Yes,
looking directly at you?
directly at me.
What about on July 4th? Well, let me ask that a different way. Was she looking directly at you on July 4th?
Yes,
That's all the questions I have, Your Honor.
Any recross?
No, Your Honor.
May this witness be released?
Yes. I'm fine with that.
Yes, Your
All
Honor.
right, so thank you very much for your time and testimony. That concludes your testimony, Ms. Norton. You're free to watch the remainder of the trial if you wish, because you will not be recalled as a witness, ma'am. Any other witnesses, Mr. Mitchell?
Yes, Your Honor. State will call Sergeant Quentin Hollis to the stand.
Okay, ladies and gentlemen, good morning once again. TCF Live on a Thursday. So as we wait for this next witness to come up to the stand, if you have joined us mid-trial here, this is a bench trial in front of Judge Mercer. Basically, it's neighbors behaving badly. The one neighbor is charged with stalking. Quite honestly, they both seem like hideous human beings, but we'll find out more as we continue. By the way, join us tonight, 8 p.m. Eastern, 5 p.m. Pacific, right here on this channel for Sidebar. It is Choose Your Own Adventure night on Sidebar. The chat will determine what the panel talks about, so be sure to join us again, 8 Eastern, 5 Pacific, and I'll get that episode posted right after the show today.
Mr. Mitchell, whenever you're ready.
Thank you, Your Honor. Excuse me. Good morning. Could you introduce yourself to the court?
Quentin Hollis.
And where are you currently employed?
I just retired from Sneed's Police Department. I'm still on the reserve, but
Okay. What was your rank and title at Sneed's Police Department?
I'm sergeant.
And how long were you working at Sneed's Police Department?
I think I worked there about 2.5 years.
Have any other prior law enforcement experience beforehand?
43 years altogether.
Okay. And were you employed with Sneed's Police Department from May 22nd, 2025 to July 26th, 2025?
Yes.
And were you on duty during, well, actually, I'll ask a different way. Were you on duty on May 22nd, 2025?
Yes.
And on that day, did you respond to a call at 8183 Pope Street in Sneed's?
Yes.
And that's in Jackson County, Florida?
Yes.
When you arrived, who did you make contact with?
Made contact with Ms. Norton first.
What were the circumstances for being dispatched to that location?
It was, I believe, called in as a kind of a stalking or harassment complaint.
Let me ask a clarifying question. You said May 22nd. Is that what you mean?
I'm
March
sorry, March 22nd.
Okay,
March
all right.
22nd.
Thank you. Go ahead, please.
March 22nd, you responded there
Yes.
and you spoke with Miss Norton.
Yes.
Did you collect a statement from her on that day?
Yes, I don't believe it was a tape statement, but I did collect information from her. Yes.
After speaking with her, did you speak with Miss Barfoot?
Yes, I did.
More specifically, Marlene Barfoot?
Yes.
Is Marlene Barfoot in this courtroom today?
Yes, sir.
Can you please point around, identify her by article of clothing? And you point to your left.
Yes.
And once again, Your Honor, witness has identified the defendant. What did you speak to Miss Barfoot about?
Just talk to her about the allegations made against her and ask her to please refrain from any harassing type behavior against Ms. Norton.
Did she say anything in response to that?
She denied most of it for the most part.
So no arrest was made on that day.
No,
Did you speak with anyone else on that day?
I don't think so.
At some point later, did you learn of an active injunction against Ms. Barfoot?
Yes, I did.
And was that information provided to you?
Yes.
Do you remember what date it said the injunction was enforced?
There was a lot went on with this case. I'm trying to remember the exact date, but I don't recall.
Does on or about May 7th, 2025 sound about right?
Yes.
So, and are you aware if Ms. Barfoot was served with this injunction?
Yes.
And so she was aware of it.
Yes.
After the injunction was served on May 7th, 2025, did you receive any further contact from Miss Elizabeth Norton?
Yes, I did.
And what did she call you about?
She called me to report that there were continuing incidents of varying degrees of severity that that could be considered violations of the injunction.
What did you say in response?
I advised her that that we needed proof, that I would help her, but if it was one person's word against another, it would be difficult to prosecute. And that I encouraged her to get a notebook and keep notes daily, whether things were good or bad, about any interactions and what was going on. And if she had an ability to record with her phone or any other way, videotape any possible violations. And she said that she was going to get a small, like a body camera that you can order offline.
Okay. But this was your advice to her.
Yes.
And at some point later, did you hear from Miss Norton again?
Yes, I did.
And at that time, did she provide you a copy of her journal?
Yes.
And you had a chance to look at her journal?
Yes, I did.
And did you use that journal in an effort to assist in your investigation?
Yes, I did.
And did she also provide you with any videos or recordings?
Yes.
Can you remember what you observed in those recordings?
Like I said, there were numerous different incidents of different severity. Usually it was Ms. Norton in her yard or on her own property, and Ms. Barfoot on her property, and there was no one else around at the time, and Ms. Barfoot would be saying things that appeared to be directed at her.
And could you hear Ms. Barfoot's voice on these videos?
Yes.
How did you know it was her voice?
I could see her in the video and then hear her voice, and I recognized her voice from talking with her before.
So prior interactions.
Yes.
Do you recall any of the things she said?
I don't have my notes with me, but there were things where she said things like, the drunks aren't going to help you anymore. And then said things about snakes and rats. And then she, in some of them, used some profanity and appeared to be calling Ms. Norton.
Go ahead, your objection.
Your Honor, I think that essentially the state's trying to do the same thing where they already played the video. Now they're trying to have Mr. Hollis narrate.
Yeah, I'm not clear if he's talking about the same video or not, but it's clearly not admissible if you're asking him to comment on a video that you have, you're asking him to interpret a video that either has been introduced into evidence or not introduced into evidence. Either way, his interpretation of the video is not admissible. The video may be, but the sergeant's interpretation is not. So the objection is sustained.
I'll move on. Did you respond to Ms. Norton's residence on July 26, 2025?
Yes, I did.
What did you observe when you got to the residence on that day?
I'm trying to remember what specifically happened on that day. There were a lot of interactions.
Did you see a spotlight?
Oh yeah, there was a spotlight on the back corner. It would have been the back right corner of Ms. Barfoot's property, just across the fence from the back left of Ms. Norton's. And the spotlight was directed, shining straight at the house of Ms. Norton, which
Go ahead.
which seemed to serve no purpose.
And you observed this yourself?
Yes,
The angle and the direction?
yes,
After observing that, did you make contact with Ms. Barfoot?
yes, I did.
Was she accompanied by anyone else on that day?
Her husband.
Okay. What did you ask her?
I reminded her of our previous conversation and that there was an injunction in place, and ask her why she was still having contact and why she was doing these things, like shining the light at her house and so forth.
What did she say in response? Well, we'll start with that one. What did she say in response to the spotlight?
She just said it was her spotlight and it was in her yard, basically. She didn't see any harm in it.
Okay. Let me go back. Did you document different dates in your report?
Yes.
Did you read off these dates and what was documented to Ms. Barfoot?
I believe I went over quite a few of the incidents, yes.
Did you go over the incident on July 4th of 2025?
Can you refresh my memory what occurred that day?
Did you ask her about snakes and rats and the Lord?
Yeah. Yes, sir.
Okay, so you asked her about that statement from July 4th.
Yes.
What did you say to her in reference to that?
And just to be clear, the question you're asking, he's talking to Ms. Barfoot.
Yes, he's talking to Ms.
Okay,
Barfoot.
I just want to make sure I understood.
And what was the last part of your question?
So I may have just stumbled over myself. I apologize.
Said he was talking to Ms. Barfoot about snakes and rats, and what was the question he asked her?
So you asked her about snakes and rats. What did she say in response when you asked her about that?
I don't know if I asked her about it or just told her about it, but her response was that she was talking to herself or talking to the Lord.
And what did you say?
I just reminded her that no contact order meant no contact, and that she could be arrested for that, for violation of the injunction, and that under that threat, it would be in her best interest to have no contact.
Okay. At any point, did you see a spotlight in Miss Norton's residence?
No, sir.
State will tender for now.
Thank you. Any questions for this witness, Mr. Atkinson?
Okay, did you show Mrs. Barfoot the video that Mrs. Norton had shown you regarding the snakes and rats, or?
No, I did not.
Okay, so you really didn't have any context for what, in order for Mrs. Barfoot to understand what you're talking about, you had no context to show her, hey, did you see this video? Did you give her context?
I told her about the video.
Okay, and so based on what you're telling her, did you say, hey, you remember that?
I think I just made her aware of it, and then she commented back.
Okay. So there was no context for what you made her aware of, correct? She didn't see the video at this point.
She didn't see the video.
Okay.
When you get through, before you get through with that date, I need to clarify something. So there were multiple conversations with Ms. Barfoot. Did the conversation, when you asked her about the snakes and rats comment, did that happen then, or did that happen 2 weeks later after the spotlight incident?
When I went back out, I'm trying to remember the date. I want to say on the 4th of July, maybe. I spoke with her about several incidents that had occurred over the past.
Obviously, all of which happened before that date.
Correct. Yes. Sir.
Okay. And then there was at least one other conversation after the 28th from the spotlight incident. At least two conversations with her.
Yes, sir.
Okay, thank you. That helped me with context. Go ahead, please.
And Your Honor, I'll go ahead and clarify. It states in your report that you made contact on July 26th, 2025. Is that correct?
Okay. Yes, sir.
Okay, and that was the incident regarding the spotlight, right?
Yes, sir.
Okay, and that's whenever you got all the context for the previous incidents, July 8th, July 24th, June 28th.
I believe that would be correct. Yes, sir.
Okay, all right then. Did that clear things up a little
It
bit?
was actually two different answers. Did you speak to her one time or more than one time?
I spoke to her way back in March,
Okay,
And then I spoke to her again in July.
that clarified a lot. Thank you.
Okay, all right. And so I want to talk about the July 26th, which is the spotlight. Mr. Barfoot was there, correct?
Yes,
Okay. Did you see who had hung the spotlight up?
no, sir, I did not.
Okay. What about on July 28th? I think there was a camera incident. No, July 8th. I'm sorry, July 8th. There may have been a camera incident. Smile, you're being recorded.
Yes,
Okay. And do you know who hung that camera up?
no, I do not.
Okay. Were you aware that that camera was hung up before the injunction was entered?
No, sir.
Okay. On the July 4th, 2025 incident, this is the snakes and rats incident. Were you made aware that the Mrs. Barfoot was actually talking to her daughter and son, or daughter's boyfriend?
No,
You were not made aware of that? Okay, but you had her journal, Mrs. Norton's journal, right?
yes, have copies of it, yes.
Okay, and were you aware in her journal that she was saying that she was pretending to yell at the occupants of the vehicle?
I don't recall that.
Okay, okay. And then did you get a call on about June 28th? Or did she talk to you about June 28th as well?
I believe so, yes, sir.
Okay, and do you know whether or not Mrs. Barfoot, did you see Mrs. Barfoot talking on the phone that day?
On the
The
video,
telephone?
I didn't see her talking on the phone, no.
Okay, do you know what incident we're even talking about, June 28th?
Can you refresh my memory?
Okay. Was there an incident where Mrs. Barfoot was taking her trash out?
I believe so, yes.
Okay, and do you know if and you weren't there, right?
Right.
Okay. Do you know if she was talking on her phone that day?
I don't know that, no, sir.
Okay, that's all the questions I have, Your Honor.
All right, any other redirect?
Briefly. When you were speaking with Miss Barfoot on July 26, did you ask her who hung the spotlight?
No, I didn't.
Okay, that's all, Your Honor.
Okay, any recross?
No, sir, Your Honor.
May this witness be excused?
Yes, Your Honor.
Thank you, Sergeant, for your time and testimony. That concludes your testimony. You're free to leave or watch the rest of the case if you wish, Sergeant. Any other witnesses, Mr. Mitchell?
No, Your Honor, state will rest.
Mr. Atkinson?
Your Honor, at this point in time, the defense would move for a judgment of acquittal. The basis for that is that the Florida statute 784.0487 subsection 4A4 requires that a person willfully violates an injunction for protection against stalking, cyber stalking issues pursuant to 784.0485, a foreign protection order according to full faith and credit clause to 741.315 by, and then subsection 4, which is the subsection that the state is going under, telephoning, contacting, or otherwise communicating with the petitioner directly or indirectly, unless the injunction specifically allows indirect contact with a third party. The four incidents that we're talking about here today are June 28th, July 4th, July 8th, and July 26th. On June 28th, there was an incident at the trash cans, according to Mrs. Norton. However, when questioned by Mrs. Norton, she didn't know if she was actually talking on the phone because she's aware that she uses an earbud and did not know, even though she didn't see anything in her hands, she could not tell whether or not she was talking on the phone. There's no evidence beyond a reasonable doubt to show that Mrs. Norton, Mrs. Barfoot actually directed that conversation at Mrs. Norton. On July 4th, 2025, the same thing occurs where we have the snakes and rats. And according to Mrs. Norton's own journal, she states that she was apparently pretending to yell at the occupants of the car. She assumes that she was yelling at her. However, whenever on our cross-examination, I had asked Mrs. Norton about where she was turned, there's some confusion there. Was she turned towards Mrs. Norton? Did she look Mrs. Norton way? She was turned towards the car with her back towards her. But she says she was looking at her. And so I'm not sure if she was looking at her or looking at the occupants of the car with her back turned towards her. On July 8th, first of all, I believe that the arrest was based on hearsay because we had the video. This was the best evidence that the state had to prove that there is a violation of an injunction. And the arrest was made based on those videos in conjunction with this journal right here. And Mrs. Norton essentially narrating, hey, this is what's happening to Quentin Hollis. And based on the misdemeanor arrest rule, I believe that he would not have had probable cause to arrest based on these incidents in conjunction with those videos.
Say that part again now, to make sure I understand that. About the misdemeanor arrest warrant, what were you saying?
Well, I believe that the misdemeanor arrest rule would say that he had to actually see these incidents happen. He said he relied on the journal entry in conjunction with the videos in order to get the context to where he could have probable cause to arrest her for this.
We're talking about the first arrest.
Yes.
Was the first arrest pursuant to a warrant, or was it
It was pursuant to a warrant.
and the warrant was based upon the complaint alleging the multiple incidents? So it was a warrant arrest.
Yes, it was.
Okay, I thought it was. Okay, go ahead, Mr. X.
And even with that, Your Honor, again, we don't know who hung the camera up. We don't know, and we do know that the camera was there prior to the injunction being entered. So how she has a complaint about that at all is beyond me. July 26th, again, we don't know who hung the spotlight up. Could be Mr. Barfoot, could be Mrs. Barfoot, but we know on the July 26th incident, based on Mrs. Norton's journal, Mr. Barfoot was outside when the spotlight was shining on her. So, Your Honor, I don't believe that the state's proved this beyond a reasonable doubt. I don't believe that they've proven that Mrs. Barfoot has had contact with Mrs. Norton direct or indirectly, and we would ask for a judgment of acquittal.
Thank you. Mr. Mitchell.
Just a moment, Your Honor. Your Honor, state would petition that we've met a burden to at least get over the JOA in this situation. The testimony and evidence has made clear that Ms. Barfoot willfully either indirectly or directly communicated towards Ms. Norton. The defense is making references to Ms. Norton's awareness of an earbud, but witness testimony and physical evidence does not support Ms. Norton's awareness of this earbud. She testified that she saw Ms. Barfoot staring at her, made these statements, and the explicitity of those statements towards her just it's self-explanatory in that situation. Also, the defense wants to mention about the camera incident, about the audible statements from the camera, but Ms. Norton testified that was the first time that she had heard about, Smile, you're being recorded. So it's irrelevant to how long the camera has been there. This is showing that, at post injunction, something has changed in the sense of the camera, that now when she steps out into her own yard, she's hearing these statements be brought forth. But nonetheless, take away from that, the jury instructions, I know this is a bench trial, but we still look at the jury instructions in the statute to determine whether or not a case is met. In this situation, it's an injunction for protection against stalking that was issued by the court against the defendant for the benefit of the victim. And, in this situation, we would say that Ms. Barfoot willfully violated the injunction by committing an act of stalking against the victim.
Whoa. That's not what you charged her with.
But, I'm sorry, wrong thing. I
Didn't
circled
charge
right
that
there.
subsection.
Wrong thing I
It's a
circled.
different analysis. Okay, go ahead.
Specifically, subsection D, which would be telephoning, contacting, or otherwise communicating with, in this case, Ms. Norton, directly or indirectly, unless the injunction specifically allows indirect contact through a third party. So we would petition that we have presented a case and the JOA motion should be denied.
Okay. So since JOAs are taken in the light most favorable to the non-moving party, in this case, the state, the confusion I have is the comparison between a probable cause analysis and a JOA analysis. Clearly, the state has not proven beyond a reasonable doubt the June 28th incident. There's one witness saying that, no witness saying anything else, and that's not proven. The July 4th incident, I need to listen to the video again. The July 26th incident is the strongest incident with the light, and the July 8th incident is nothing. It's useless. So, but I don't know that for JOA purposes, the analysis is really not reasonable doubt. The analysis is in the light most favorable to the state, as the state made a prima facie case. So it's very similar, if not identical, to probable cause. So for that reason, I'm going to deny the motion for JOA. But it's a close call, at least in 3 of the dates.
Yes, sir.
And given that, you have any witnesses you would like to call, Mr. Atkinson?
Yeah,
Or would you like
can I-
time to speak to your client to discuss that?
Yes, can I speak to my client?
Absolutely. Would you like to discuss it in the same room you spoke to her previously?
Okay, friends, the good news is we get to take a break from that while they discuss things. Obviously, they're going to figure out whether or not she takes the stand, but obviously we've got to finish this at this point. So what do we talk about here? We talk about, proper behaviors, good responsibility, stuff like that. Yet again, we've got a model of people who just don't know how to be human. Let's go back. Let's go back to Judge Mercer. Let's see what they're doing.
With his client in private, with Ms. Barfoot and Mr. Atkinson, tell me where we stand, please.
Your Honor, I believe that we'll go ahead and call Mrs. Barfoot as a witness.
All right, Ms. Barfoot, I'm going to ask that you go ahead and have a seat up here because I want to make sure that Mr. Mitchell has a chance to see you and hear everything well. So if you'll see, like you've done the other witnesses do, if you'll stand there and let me place under oath, and then we'll get you to have a seat, ma'am. Fine, right there. Ms. Barfoot, come on around and have a seat if you will. Just make yourself comfortable, ma'am. And your attorney, Mr. Atkinson, will ask you questions first.
Yes, sir.
Mrs. Barfoot, do you recall an incident on June 28, 2025, specifically what they're talking about?
Yes, just because it's being talked about.
Okay, tell me kind of what your side of the story is on that.
Well, my sister and I were arguing about my mom. My mom's in poor health and they want to bring her to Texas and I don't want her to go to Texas. So that's what we were talking about. We were
Okay.
arguing.
Okay,
But I
and
was taking my trash out and according to Joan, something else happened. So I don't know.
okay. And were you talking on the phone?
Yes.
How do you usually talk on the phone?
With my earbud in and my phone's in my right back pocket because I'm right-handed.
Okay, and were you using your earbud when you were taking your trash out?
Yes.
Okay.
I always use it. I always use it.
Okay, and so were you focused on Mrs. Norton at all?
No, I was having an argument with my sister in Texas.
Okay,
No, sir.
all right. What about on July 4th? That's a holiday?
Mhm.
Okay, were y'all having like a get together and everybody was at your house?
Yes, my daughter and her husband came over to have supper with us or lunch, brunch, late afternoon meal.
Okay, did you and your daughter have a little tiff that day?
Yes.
Okay, do you remember what that was about?
I don't remember what it was about. It's just family stuff. It's really not anybody's business. It's family
Okay,
stuff.
just family stuff. Okay,
Yes, sir.
all right then. And whenever she left your house, did you follow your daughter outside?
We were talking and first she forgot something. I had to bring it to her. And then when she came back, yes, we were talking.
Okay, and during this time, did you make this, were you upset? Let me ask you that.
Yes.
Okay, and did you make the statements about the rats and snakes and everything else?
Yes,
Okay.
rats and snakes because the grass is so high.
Was that?
I don't
direct-
want to have
was
rats and
that-
snakes.
Was that directed at your daughter or Mrs. Norton?
I'm talking on the phone with my daughter
Okay,
or talking to my daughter. But the thing is, I don't understand this right here. Joan follows us around from front yard to the backyard or her side yard to her backyard,
I understand.
recording everything,
I understand, but
everything in my life
I
and my
understand.
mother's life and my
Ma'am,
husband's life.
Ms. Barfoot, answer his
Yes, sir.
questions.
Yes, sir.
He'll ask you a question, you answer it.
you're
Yes,
talking
sir.
to your daughter.
Yes, sir.
Okay, None of that was directed at Mrs. Norton, correct?
No, correct. It was not
Okay.
directed at her.
All right. Were you even, prior to July 26th, which I believe is when Mr. Hollis had made contact with you, were you even aware of the camera making any noises or anything?
No, because I don't have anything to do with that camera.
Okay, how do you work the mechanisms of those cameras?
It's attached to my husband's phone. My daughter set it up to work on his phone. And
Okay.
he doesn't, but that camera's been broke since that incident. He broke it deliberately after that.
Okay, all right. Is that an
Mhm.
avoidance of all this drama?
Yes, sir.
Okay, all right. And what about, but you didn't hang that up?
No,
You
that
don't
was there
have-
when I moved there.
Gotcha. And you don't
Yes, sir.
have any connection with the workings of that camera?
No, sir.
All right. What about on,
And there's another camera too. It's on the other outbuilding, but it faces this side of our house. So both sides of the house are covered, is what he said.
so that's not facing Mrs. Norton's side, is that right?
No.
Okay. And then on July 26, 2025, talking about the spotlight incident, did you put that spotlight there?
I would have no reason to put the spotlight there.
Okay.
No, I didn't put it there.
Okay. And if you didn't put it there, do you have any idea who did?
Jimmy,
Jimmy did. Jimmy is who?
my husband.
Okay. Did you direct Jimmy to put it there?
No.
Okay. Do you know if he had any reason to do that or?
Well, every time we come into our yard, we could see a bulb shining. And if you look at it, it looks like it's shining right at you.
Mhm.
I mentioned it to him that she had a spotlight shining on us.
Okay. All
That's
right.
all.
Okay. And so as far as these issue goes, June 28th, July 4th, July 8th, and July 26th, you're never directing anything to Mrs. Norton
No,
directly or indirectly.
no. no.
Okay. Has there since been a fence put up?
Yes, we built a privacy fence and it's double walled, double thick. It's very expensive. So that I can't see her and she can't see me.
Okay.
Mhm.
And that was kind of a process.
It took a while, but it's time. My husband's elderly.
Okay. So your husband put that up?
Yes.
Okay. Your Honor, I think
With
that's
the
all.
help of my son-in-law. I'm sorry.
Okay. You didn't help at that at all?
I was not allowed out there.
Okay. And that was because,
My husband kept me away from the fence. He don't want me to anywhere near her or
okay.
talking to her or anything
All right.
because I don't want to go to jail.
All right, Your Honor, that's all the questions I have.
Thank you, Mr. Mitchell.
Yes, Your Honor. So you said on June 28th, 2025, you were on the phone with your sister? You just testified.
What was the incident?
It was regarding the statement, "You goddamn bitch, I'm the one that fought in the war."
That's me and my sister, yes.
So you were speaking to your sister.
Mm-hmm.
Is that a good way to speak to your sister?
Sir, that's not for you to judge.
I'm asking the questions here. Is that a good way to speak to your sister?
My sister and I have a strained relationship. We talk to each other like that.
Ms. Norton came up here and testified that as that was being said, you were staring in her direction.
I was told not to look in that direction. That's why we built the fence.
And yet, according to her testimony, you still was looking at that and saying that.
Well, like I was saying a while ago, anywhere I go in my yard, Miss Norton is there with the camera doing this. So yes, she probably got me looking. What am I supposed to do? I'm in my backyard.
You were here when you heard her testify that you threatened to kill her at one point.
I was
I'm gonna
here when I
object
heard
to
her
that.
testify.
It's beyond the scope of the complaint.
Yeah, help me out with relevance on that.
This is what
That's something prior to the injunction.
this is something prior to the
allegedly?
injunction that Ms. Norton testified to.
So how is it relevant I know there was no objection at the time she testified, but I was waiting for one. How is that relevant to whether she violated an injunction later? How is the statement from May or
It's relevant
March?
to answer, to basically say, why is she recording in all these situations out in the yard? Because she is scared of Miss Barfoot based on previous interactions and statements that have been made.
And that also is irrelevant. Whether she's scared or not, it's not relevant. Whether she violated the injunction is the question. So I think that's a valid objection. I'll sustain the objection. I would have sustained the objection earlier had there been an objection during direct when y'all were questioning, asking all the questions about things before the injunction. She's not accused of those things, but go ahead, please, your next question, Mr. Mitchell.
You received You received a copy of the injunction, correct?
Yes.
And you
Yes, sir.
acknowledged it.
I'm sorry?
And you acknowledged that there was an active injunction.
Yes, I had to sign the paper. Yes, sir.
Okay.
May I add that I volunteered for all that
You just
to
did.
try to
so.
put her at ease. Joan and I used to be friends. We had a good relationship.
You used to be friends?
And I wanted to, I did apologize to her.
Oh.
Judge Garcia let me apologize to her right here in court.
You said you used to be friends.
Yes,
Why are you not friends anymore?
because of this incident, all this incident.
You sure there's nothing else?
This is all getting
You know,
really
I'm gonna
personal.
object. I don't know what the
Yeah,
line-
this has nothing.
I don't know what, that, the friends had nothing to do with it, Mr. Mitchell. Next question, sustain.
So the spotlight. Why'd your husband put the spotlight out?
I didn't say that he did, but I don't know.
Actually, I'm sorry, go ahead.
I said I didn't do it.
No, you
I-
said your husband did it. Go
You
ahead.
said your husband.
Oh, excuse me, I'm sorry.
Do
Okay.
you know why your husband did that?
No,
But do you know the purpose of that spotlight?
Objection asked and answered. I'll
Purpose of-
I'll withdraw that.
But you were aware of the spotlight
yes, when the officer came to the house, yes.
and you were aware of the direction it was facing.
He said which way it was facing. Yes, sir.
I didn't ask about him. I asked about you. You were aware.
I'm
of it.
going by what the officer told me, sir. I don't know anything about that spotlight.
So. But you knew the spotlight was there. I'm asking you, you knew the spotlight was there?
Same question again, or what?
Man, you don't play lawyer. Just answer his questions. If there's objection, you've got a great lawyer there. He'll make the objection. Answer the question if you can. Do you know the answer?
Yes, sir.
Answer the question then.
And the question was what?
You were, wait. Did you know the spotlight was there?
Yes, sir.
And you spoke with Sergeant Hollis about it?
He spoke to me about it, yes.
Okay. So you became aware of the spotlight after you spoke with Sergeant Hollis.
Yes.
Did the spotlight come down after that?
I'm not sure.
You're not sure.
I didn't take it down.
When did it come down?
I have no idea, sir. It wasn't very important to me.
But you were aware in the direction and angle it was facing.
From what the officer said, yes.
And you were aware it was facing Miss Norton's house.
Yes.
And even despite knowing this,
I didn't put the spotlight there.
listen carefully. And even despite all this, you didn't take any measures to get that spotlight down after it was brought to your attention.
That's correct.
So the snakes and rats statement,
Yes, sir.
you mentioned, you said that because the grass was so high?
She mowed all of her yard except for this part, like about this big of a strip all the way down. And it was up against our yard. It's her property line, but it's also Jimmy's property line. And she let that grass grow this tall. And she wasn't gonna mow it. Anyway, I was telling my daughter, we're gonna have snakes and rats, snakes and rats. We're gonna have snakes and rats. What's so bad about that?
And was it directed at Miss Norton?
I didn't even see Miss Norton out there. We never see her out there. She catches everything on camera and then reviews it all
That's-
day long. That's all she has to do.
That's not what you just said earlier. You
Don't
said
have a
you
lot.
see her all the time recording in your yard, so,
Well, yeah, when she's out there with the camera, we see her, but
but you were,
normally we don't go out when, we're outside and we're doing our thing. We don't know she's out there. She don't make no noise. But she's always recording stuff. That's evidenced in that book she gave you called her journal. I'm trying to figure out why I'm being called a stalker when she's the one stalking, recording my whole family.
but you agreed to have an active injunction against you.
Yes, in my stupidity, I did not know. Had I known,
And despite all that, you understand the consequences.
yes, sir, I do.
And you could see how a spotlight shining through Miss Norton's windows could be contacting her indirectly.
It didn't affect me because I didn't put it up there, sir.
Still on your property,
It's not my property, it's my husband's property.
but you live with your husband.
Yes,
You
temporarily.
live in that
Yes.
house.
Yes, you're correct.
So it's joint property.
Yes, sir.
Me, all my questions for now, Your Honor.
Thank you. Any redirect?
You stated that there was a spotlight shining into your yard as well?
Yes.
Okay,
But the officer looked at it and said it wasn't a spotlight,
okay,
but we thought it was.
all right. And again, you didn't have anything to do with that spotlight. You didn't know about it until the officer brought it up to your attention?
Right.
Okay, and so did you feel like you had any obligation to take it down? Do you think that he maybe should have been talking to Jimmy Carfoot?
Exactly.
Okay, all right. Your Honor, I think that's all the questions I have.
Right. Thank you very much for your time and testimony. Now you can have a seat
Just,
back to you.
just a second, Your Honor. I may have brief recross. I want to take a look at something, just. No other questions.
Next to your attorney, ma'am. Thank you. Any other witnesses, Mr. Atkinson?
No, sir, Your Honor.
Anything else from the state?
Nothing else from the state, Your Honor.
All right, so. So I want to hear closing arguments, but I'm going to try to limit them for you both. All right. So I'm not going to find that she proven the case beyond a reasonable doubt for the June 28th incident. Her explanation is at least somewhat reasonable. There is reasonable doubt on the June 28th incident. That's the one with allegedly the phone call with her sister. The snakes and rats incident, I want to hear that portion of the DVD again.
Okay.
Only the audio portion. I couldn't hear hardly anything the first time. I made a note, almost useless on that DVD, but almost means I heard something. So can we play that part again? Because I may want to try to do some talk about that in closing.
Yes.
So while you're looking that up, I do want to hear you on the light shining. If the state's proven their case, that's going to be the strongest argument. And the July 8th incident with the cameras, the talking cameras, the state's not proving their case. So there's just not enough evidence there. So we've limited it down to 2 dates at most, possibly 1 date. So if you'll play State's Exhibit C, the portion with the audio part, I don't need to see the whole thing again.
Oh, it's about the halfway point, I think is when it comes in.
As close as you can get, please, and we'll turn the volume up as high as we can get it, please, so we can see and hear it. And then once we do that, I'd be glad to listen to closing arguments from both the state and defense.
That's the entire portion.
Thank you, Mr. Mitchell. You can talk about anything you want in the closing argument. I'm just telling you that I'm going to have a really hard time finding that you've proven your case on those other 2 dates. I really am interested in primarily in the 2 dates remaining, which would be July the 4th and July 26th, Mr. Mitchell.
July 4th and July 26th.
And also specifically, the other question I'm going to have is the specific subsection you chose to file under, because that requires communication and how you view is that that's communicating either of those dates.
Okay.
Well, specifically, it requires contacting or otherwise communicating.
I got you, Your Honor. All right, so Your Honor, state presented evidence regarding the July 4th incident, which we just reviewed again, which was the snakes and rats incident. I know we heard Miss Barfoot take the stand and she tried to say that the snakes and rats was a result of Miss Norton's grass being very high, and that as a result, snakes and rats could be there. The problem is with that statement is that it's in conjunction with, I hope you know the Lord, snakes and rats. There's no correlation when it comes to the grass being high and the fact that she's conjoining that with, I hope you know the Lord. We heard testimony from Miss Norton that as this was happening, the car was being pulled out. There was nobody else in the yard. So she was looking and facing Miss Norton as that was happening. And she was saying this, and Miss Norton testified that that is what she heard. She recognized Miss Barfoot's voice as it comes to that. We would say that we have proven beyond a reasonable doubt that this is contact. According to Miss Norton, this is direct contact in her situation. Miss Barfoot may try to say that this is indirect, but regardless of whichever it may be, this is contact nonetheless, which is in violation of the injunction. As for July 26th, I know the court just basically said that there was, how can that be considered contact when it comes to this? We would actually say that this is circumstantial evidence to show that, Ms. Barfoot is intending to have contact. And, the reason we say it's circumstantial to show intent to have contact directly is the light is shining directly into Ms. Norton's windows. It serves no other purpose than to shine directly into the window. We saw video today that shows the spotlight stayed on even during the day, serving no purpose at all. And this was after the July 4th and other incidents, but I know you want to focus mainly on the July 4th incident. Miss Barfoot was made aware of this, and Miss Norton testified that even after Miss Barfoot was still made aware, and the positioning and angle of the spotlight in conjunction, she still did nothing about it. She testified to such as she took the stand. She didn't try to remedy it. She tried to say it was my husband making that decision, but she was aware and she still kept it up for that purpose of indirectly contacting Miss Norton. We were mainly focusing on, this being in conjunction with the other moments to show that this wasn't just an accident of indirectly or directly contacting. This was intentional. This was willful on behalf of Miss Barfoot. And we would say that based on the evidence presented and the testimony that has been presented and testimony that has even been contradicted at times, we would say that the state has proven this case beyond a reasonable doubt and request a verdict of guilty as charged.
Thank you, Mr. Axon.
Regarding the July 4th, 2025 incident, I believe that Mrs. Barfoot got up there and testified that she was talking to her daughter the entire time. She was directing her contact to her daughter. Now, whether it was about Mrs. Norton at the time, talking about, well, she didn't mow her grass or they were in a tiff or whatever, it did seem like she was upset talking about the snakes and rats. And I don't know if there was fuel to the fire coming from everywhere, but she was directing that contact towards her daughter. And as a matter of fact, if you look at the journal on the July 4, 2025 incident of Mrs. Norton, this is on page 14, it states, Marlene saw me, then turned back to the car as it backed out and started yelling things. She was apparently pretending to yell out to the occupants of the car, but was yelling to me. So based on her perception, not her opinion, but her perception, Marlene Barfoot wasn't even facing Mrs. Norton. She was yelling at the car. Now, she assumed that she was trying to direct that contact with her, but that's just a statement of hypersensitivity that, oh, I got this injunction against me, so everything that Mrs. Marlene Barfoot does, that must be at me. And so July 4th, 2025 incident has not been proven, not only by my client's testimony, but also by the journal here. The July 26th incident, I liken that more to the July 8th, 2025 incident, and that Both of the observations that Mrs. Norton had seen were based on mechanical objects, the camera that Mrs. Marlene didn't have anything to do with, the spotlight that Mrs. Marlene didn't have anything to do with, and she testified, Mr. Jimmy Barfoot hung that up there. What the reason was, I don't know. However, it's not intentional, it's a willful violation. So if Mrs. Barfoot had absolutely nothing to do with anything that happened with the spotlight, how could she have her intent be willfully violated? I mean, I just don't see how the direction should have been at Mr. Barfoot, not Mrs. Barfoot. She wanted to stay out of that. If they told Mr. Barfoot to take it down, then, and he didn't do it, that was on him. Law enforcement should have told him to take it down. But even by that testimony, it appears that Mrs. Barfoot has stated that that was the same thing that Mrs. Norton was doing towards her. So to me, this seems like a tit for tat sort of thing, Your Honor. In that scenario, Mrs. Norton shines it on their house. Mr. Jimmy gets upset, starts shining the spotlight on her house, and Mrs. Marlene Barfoot, by her testimony, had nothing to do with any of that. And so based on the evidence that the state has presented, I don't believe they've proven their case beyond a reasonable doubt. And I would ask for a verdict of not guilty to all counts charged.
Okay, thank you. So I want to find the state has not proven their burden as it relates to two dates for sure, June 28th and July 8th. As it relates to July 4th, that was a lot closer case. The journal also says Mr. Axon's quoted the portion of the diary 3 different times, but he always leaves out the next sentence, which says they kept backing out of their car and drove off. After they drove away, she kept on yelling. So her diary says after they drove off, she kept yelling. And I could hear her say the word Lord, and I could hear snakes and rats. But the biggest problem I have with the defense's version is the spotlight. The spotlight was intentional. The only question is, 2 questions are, number 1, she have a role in that? And number 2, does that spotlight violate Florida statute 784.047 subsection 4A4? And I find Sergeant Hollis's testimony to be very important because he said when he confronted her, she said, and I quote, it was her spotlight and it was in her yard and she didn't see any harm in it. So I find her testimony to be not credible, and here's why. She was entirely inconsistent. She first said that her husband and she had a conversation about it before the spotlight was put up, because she brought to his attention that the other lady, the alleged victim, had a spotlight or a light of some type. And then she later on during cross-examination said she didn't even know he'd put the spotlight up. Well, you can't have it both ways. Either you had the conversation and you knew the spotlight was going to be put up, or you didn't know. I don't believe her testimony. I felt like she was less than credible. I found Sergeant Hollis's testimony to be very credible. So I think that she had a role in putting the spotlight up and having the spotlight put up, and that is a direct violation of the court's order. That is certainly contact with the petitioner. And then it's further, my belief, my lean towards thinking that's proven beyond a reasonable doubt is strengthened by the fact that it's left up all day and all night, or at least all night, not perhaps all day. And that's proven by a video the next morning. So had it been me and my husband really had a light up and the sergeant came and said, you need to take that down, it's shining at their house, and my husband wouldn't take it down, I would have left before I took a chance on being accused of violating the law. I don't think none of that happened. I think they were just making a point. She was making a point that she could do what she wanted to. So I think the others are marginal, but I'm going to find that the state has proven their case beyond a reasonable doubt, specifically as it applies to the spotlight. Having said that, I'm comforted and encouraged by the fence, and I think that's going to play a role in sentencing on where we go from here. So I'm finding her guilty. The state's proven their case primarily because of I don't think there's any reasonable doubt that she had put that spotlight up or participated in the spotlight or participated in not taking it down based upon the reasons I've already said. Given that, what's your request and suggestion on sentencing? You go ahead and deal with sentencing now at this point? Or do you have something
Can I
else?
talk to the state for a second, because she does still have a pending charge regarding October 22nd. So if we're going to do sentencing, I'd like to make sure that we can get all that one together.
And based on prior conversations when your dad was here, my impression was this was the stronger case. Is that case going to be dismissed in light of the verdict today?
In light of the verdict today and in light of her being sentenced for the case today, the state will go ahead and dismiss case number 25561 on the
And you
record.
don't know what the sentence is going to be, but you're still confident.
Well,
that-
actually, let me wait, but
And I may put on probation. I don't know.
yeah.
My main concern is continuing the status quo if everything is good. And so let's just wait and see. So I think that
Don't
depending
write
on
that
what
down,
happens, the state may be dismissing that charge, Mr. Atkinson.
Your Honor, I'll have to go ahead and go forward with the October 22nd date at that point in time. They think they can prove it prior to sentencing, then let them prove it.
Well, no, what else?
What's that? I know. You want to, yeah. Your Honor, I'd like to go forward on that hearing and let the state see what they have to prove.
So your preference, it would be to try the case for October and then proceed to sentencing if she's convicted of that.
Forget it. Forget it. State will dismiss 25561
Okay, that's logical, given that you made me and Mr. Curriaxon aware when y'all chose to schedule this, you told us in court that was a weaker case. And I actually did not revoke her bond because that case appeared to be pretty fragile, for lack of a better term. Okay, so that case is being dismissed. That leads us to sentencing in this case. And I've heard from the defendant about the fence and everything. What I've not heard is from the alleged victim about the current status of things. I do know, just from reading the file, that there was a request to extend the injunction that Judge Garcia heard and she denied. What I don't know is Ms. Norton's position on whether things have calmed down and whether the fence has fixed the problem or problems. So do you want me to hear from the state? Would you like me to hear from Ms. Norton before I hear from Mr. Axon or his client on sentencing?
I think Ms. Norton would like to speak to you prior to sentencing.
You certainly have the right. Ms. Norton, if you'd like to speak, you need to come up here, ma'am, so that we can make sure everyone can hear you. And Mr. Mitchell or Mr. Axon may have some questions for you.
Yeah,
Right there. So Ms. Norton, Ms. Barfoot testified that the fence had been put up and basically she had apologized and she's given the impression that things are better. Is that accurate from your perception?
No, sir.
Tell me why is it not accurate? What's happened?
Things have just continued from the end of July. Things have just stayed steady.
Let me be clear in my question.
And-
I'm going to be more clear in my question. Since the fence was put up, how's it continued since the fence was put up, or did the fence fix the problem?
The fence is not completed. The fence is maybe 2/3 of the way finished.
Along your joint property line, it doesn't cover the whole property line.
No,
yet.
it does not. I have a picture of it on my phone from yesterday, and there's areas where there's just blue tarps. And there's enough pathway through the brown barns, what I call it, but a garage, I guess, on her property, that between that building and my fence is probably about, because my chain link fence is still up, that divides our properties. They just built the wooden fence on their side.
On their side of the chain link. Okay.
Right, but there's enough room that, people can walk back and forth between their barn and my fence. And then, there's the barn. And then like from here to the end of the fence line is a blue tarp. And then from the other side of the barn to where they decided to stop their building on the fence, there's another large blue tarp that's just hanging there.
Ms. Norton, since the last time Ms. Barfoot was arrested, the second arrest, where she stayed in jail a few days, and then we had a hearing and I didn't revoke her bond. Since that time, has she contacted you in any way? It's not a
I'm
complicated or
trying to
trick
think.
question. It's really simple.
October.
No, since she was arrested the last time, has she contacted you? It's a simple question.
I
You would
can't
know it if she
recall.
has.
I don't think so.
Okay. Mr. Mitchell, you have any questions for Ms. Norton?
And Ms. Norton, you understand that per stipulation, she cannot go to jail as a result of the sentencing. You understand that, correct?
Yes, sir.
Is there any type of conditions you would want her to have as a part of her probation? And you understand the judge will make the final determination, but you can recommend it and he can take that into account.
I would like to not have contact. This has taken up a long time. And I'd like not to have any more contact at all,
And the
I don't-
injunction's gone now, correct?
right?
Okay. Any
And,
other conditions that you're requesting?
I don't think the fence will help the problem because all she'll do now is just stand on the other side and yell, this won't end. It'll happen again. I know it will, but I think that alcohol is a big factor in things. I think,
Is there a reason you didn't, well, you may have, there's no testimony of it. There was testimony that Sergeant Hollis suggested to you to get a body camera. You could order one off the internet. And instead of doing that, we had a very poor cell camera photo of a ground and a garbage can. Is there a reason you didn't follow that advice?
I did get
You did get a body
a
camera.
body cam, but
Okay, and so tell me, have you used that?
I've used it. I've tried to use it.
Does it just clip on your shirt or something? Is that how it works?
Yes, but I've got it now and I know how to use it now.
Okay.
But, I do have that
That's something you
available.
got after most of this had already happened, though.
Well, I hate just to admit this, but I'm on a budget that's more than tight and I had to wait till I could afford it.
That's fair enough. I understand. I've got 4 children. I can understand that.
And
Just
the-
today, I get paid tonight at midnight.
And
I can tell you exactly when I get paid, so I
I-
can understand.
I just don't want this kind of thing. I can't take it.
Okay. Is there anything else that I haven't asked you that you want to make sure I know about? Because this is your last chance to tell me something. If it's important, you need to tell me now.
Judge, would you like to see a picture of what she's talking about with the fence?
No,
I did send him a picture of the fence the other day.
thank you, though.
Oh, okay.
But yeah, I'm afraid. I'm afraid of her. She gets so far out when she gets out there that it's
You-
scary.
Do you understand that a standard condition of every probation, if I put her on probation, is that she can't possess or consume alcohol?
I
Did you
didn't
know that?
I didn't know anything about all
That's
that.
every probation case in Jackson County. That's a misdemeanor probation. They can't possess or consume alcohol. So that's a standard if I put her on probation. Anything else that you want to tell me? Mr. Mitchell, any other specific questions you'd like to ask her?
So you said that you want her to get help with alcohol. Is that correct?
I definitely,
I can't do that.
Yeah.
There's zero testimony that alcohol was involved in this. I can't order alcohol as a
I
condition
understand.
other than no alcohol.
I understand. Yeah, no other questions, Your Honor.
Mr. Axon, any questions for the witness? Thank you very much, Ms. Norton. Appreciate your
Thank you.
time. Anybody else you may hear from? You may hear anything else from the state, Mr.
No,
Mitchell?
Your Honor.
What is the state asking?
The state is asking for what's been the offer from the very beginning, which is 1-year probation with the standard conditions that come with probation, no contact with Ms. Norton.
Is it safe to assume that Ms. Barfoot has no prior criminal history?
She had 1 prior DUI. I think it was like 10 years ago or something like that, but that's it.
I normally would not consider non-reporting probation. I am considering that possibility in this situation with the condition, obviously, of no contact, no alcohol. But what's the state's position or thoughts about non-reporting probation? And I'm not saying I'm going to do that. I'm just saying that's one of the things that's gone through my mind. And I may do non-reporting for a certain period of time or reporting only for a certain period of time. I don't know.
I think reporting probation, but we're not opposed to like for a certain period of time. we'll leave that up to your discretion.
Mr. Axon, I'd be glad to hear from you or Ms. Barfoot, either one or both.
Yes, Your Honor, and I believe the testimony that has been here today has been that there has not been any incidents whatsoever for the first 6 years of their neighborly relationship up until March 22nd, 2025. So there has been nothing, no issues up until that date. That was Mrs. Norton that testified to that. Since that date, even though we have all these other incidents that happened and you found her guilty on, there's not been any contact from October 22nd, 2025 up until now.
And help me out with that date. Is that the date of the second arrest?
That's the date that she was alleged to have her last contact with her.
Okay.
Yes. And so after that date, she's had no contact with her. She's taken more steps in order to avoid contact with her. She says she's her husband deliberately broken her camera. They've made strides to put up a fence, I understand that she may be elderly. I can, as an officer of the court, her husband is also elderly, and they have had troubles putting that fence up, but they've taken a lot of measures to try and do everything they can to mitigate the circumstances that caused this issue between her and her neighbor. I think that, the amount of effort and the amount of money that they put into this is testament to their commitment not to have contact with Mrs. Norton. And, her able to see through a little gap between a blue tarp and a fence, I'm not sure if that rises to the level of she needs to be on probation. So we would ask for a fine, Your Honor, and that'd be the only condition.
What was you were involved in the injunction here. What was the request? How long was the request to extend the injunction for that was denied?
Your Honor, there was a few different ones. I think that, to be honest with you, and this is no, putting off on anybody. But the original petition or the original motion to extend was done by Mrs. Norton. The request was for permanent injunction.
Okay.
Mrs. Myron had gotten on the case.
Is that an attorney? I don't know who that is.
Yes, Your Honor. Yes, Your Honor. By Mrs. Jan Myron. She had gotten on the case. She had requested a extended but terminate after a year, I believe it was. I'm not sure if her and her client were on the same page with that. They filed a amended motion on that, and I believe that was for permanent injunction, but those have since been denied.
Okay, thank you. So what I'm going to do is this. I'm going to, having found Ms. Barfoot guilty of the offense of violation of injunction for cyber stalking or protection, or was it just a regular injunction?
Stalking in that situation.
The violation of injunction for, what was the original injunction? I've got it here. I printed it out, I believe.
That's what it was for stalking.
For stalking. The original injunction was issued for stalking allegations. Having found Ms. Barfoot guilty of that offense, I'm going to withhold adjudication of guilt. I'm going to place Ms. Barfoot on probation for 11 months and 29 days. Ms. Barfoot, I'm going to waive the court costs and fines. The reason I'm going to do that is you've already spent a substantial sum towards a fence. And I think that's going to go a long ways towards solving the problem. So there's not going to be any court costs and fines. There is going to be the standard conditions of probation. The standard conditions of probation include reporting in once a month to the probation officer, at least for 6 months. I'm going to impose the standard cost of supervision, which is $45 a month, Mr. Goodson. $40 a month, but there's no court costs and fines, just the cost of supervision. There is most importantly a condition of no contact. And by no contact, I mean no contact. Not talking to her, not looking at her, not talking about her in her presence where she can hear, because I'm going to interpret that as something you're saying with the intent to get a rise out of her. And it's just, you don't need
Yes,
to.
sir, because now I know she records everything you say.
So assume that. That's what I would
She
assume.
does.
And what I'm going to do is if you do that for 6 months, you've stayed out of trouble and there's been no allegations of violations, and I'm going to strongly consider early terminating your probation after a period of 6 months.
Thank you.
So basically it's $40 a month, stay out of trouble, stay away from her. There is a condition of no alcohol, not because of testimony, but because I do that in every probation case in Jackson County. Never not done one. Never allowed alcohol use in a single case, and I don't plan to, because I think that's a big part of a majority of the cases we have. They're based on either alcohol or drug abuse or both.
Yes, sir.
I believe I've covered everything. Possible early termination, Mr. Goodson, waive court costs and fines, impose cost supervision, no contact. There were no other specific requests by the state. No contact was the main thing. I don't think ordering counseling is appropriate in this particular case. I don't know that I've missed anything. Mr. Mitchell, anything that I may have missed from the state's perspective?
No, I don't think so.
Any other specific relief that I may have not have addressed other than early termination, which I know that you always ask for, Mr. Axon?
Yes, Your Honor, and I just want to clarify the 6 months is going to be in-person reporting, correct?
I'll tell you what I'm going to do is I'm going to require her to report in person for at least 3 months. Mr. Goodson, if at 3 months, if there's been no allegations that concern you, I'm going to give the probation office discretion to make the remainder portion non-reporting if they wish. And I'm going to require the state, excuse me, Mr. Goodson, before you did that, I would want you to interview Ms. Norton and make sure there's been no problems. So if you call Ms. Norton and she says there's been no problems, I have no problem with the state making the remainder balance non-reporting, which essentially may mean 3 months reporting, 3 months non-reporting, early termination, possibly. Okay. I think that's the fairest thing I can do, given the testimony I've heard. I do feel like there was attempts to avoid Judge Garcia's order, and I think it's the appropriate way to deal with it. Mr. Goodson, anything else from the probation office I may have missed? And Ms. Norton's consulted and says there hasn't been any problems, and it would just go, she wouldn't get off at that point. She'd just go to non-reporting. And if she goes to non-reporting, she would no longer pay that supervision fee. So you'd only be paying $40 a month for 3 months, potentially.
Does the time that I spent in jail help at all?
Well, because you're getting probation. If you've got a jail sentence, you would get credit for that, but I'm not giving you a jail sentence. You don't want a jail sentence,
No,
right?
sir.
Yeah,
No,
it doesn't, you don't get credit towards probation. I would like to point out, as far as I know, I may be wrong, but after 40-something years, this may be Sergeant Hollis's last time testifying.
Oh.
Potentially, Sarge. Is there plans for future law enforcement position in the future, possibly? I heard rumors there might be a candidate one day. We'll see what happens with that. But I think that's everything I know of. Let's see if there's anything else from the parties. Mr. Goodson said there's nothing else from him. Mr. Mitchell, anything else?
Nothing from the state.
All right. Thank you all. Ms. Barfoot, just suck it up, get this behind you, stay away from her, and whatever friendship y'all may have had at one point, it appears to be over.
Yes, sir.
If y'all try to work it out after you're off probation, I can't control that, but it's not going to happen for the next 6 months at least. All right. That concludes today's hearing, today's bench trial.
Alrighty, friends. By a vote of 100%, none of you think she's going to make it through her probation, and you're probably right. Neither one of them are good people. That's clear in my mind, but the defendant there, I'm sorry, she's nasty. Not a fan. Glad she's not my neighbor. I've got enough trouble with the neighbor that I have. Definitely don't want that. Hey, thanks for watching this clip from TCF Live. If you enjoyed it, please leave a comment, like, and subscribe if you haven't already. And you can join us weekdays live, 9 a.m. Eastern, 6 a.m. Pacific, right here on this channel.